So yes, today we'll be discussing about maxims. Okay, maxims of equity. Now, maxims are not only there in equity but also in common law, and many of them are, more or less, many of them are overlapping as well. Okay, the thing is, let's start with what is the importance of these maxims. Okay, why do we need maxims in the first place? Okay, so what are maxims? So these are nothing but short phrases, short statements, sentences, that convey a particular idea of law. Okay, a particular idea of law. Okay, now, when I say idea of law, what law? Are they enacted law? No. So, what are they? In common law, maybe certain principles which have evolved over a period of time. In equity, what are they? So, in equity, we understand them to be, overlapping with certain, moral ideas. Okay, certain moral ideas. But then, if we equate maxims with moral ideas, then the problem is that when these maxims are applied in, deciding a matter, are we saying that moral ideas are playing a part in, in the outcome of a particular matter? So maybe in earlier times, until equity, law of equity became ossified, okay, became more concrete. Okay, maybe then, until the time when you know the conscience of the chancellor used to be really the subjective, discretionary conscience of the chancellor, maybe you could equate that with their personal ideas of morality. But since Lord Nottingham, as we studied earlier, okay, since he started mm, mm, following precedents, okay, since then, they have become specific laws under equity. Okay, so if there are very specific, for example, equitable estates, rights and interests, which are now separate sets of law in England, okay, then what is the importance of maxims? What do they do, and what is the point in studying them? Well, some thinkers say that there is no point in studying them, because uh, they don't help you with anything. Okay, are they universal principles? Are they universally followed? No, they are not followed universally. In most of the cases, once we describe a maxim, there will be exceptions to it. So if there are exceptions, then what's the point in having maxims? So instead of maybe judges deciding a matter by referring to so and so maxims, they should probably tell us the actual reasoning that goes behind it. Okay, let the decision making process be very transparent, rather than just using abstract principles and then saying that, okay, this is the outcome of that application of that abstract principle. So that's very hazy, isn't it? That's very blurry. So instead of using such set of words conveying some vague ideas, okay, is has its own problems. And then how do you come from those general principles that you find in maxims, and then come to particular conclusion in a matter? Okay, so these problems remain. Apart from that, another thing that you will see here is that, forget about other maxims. There used to be many more maxims. Now we are studying only 12. Now within these 12, you will see that one maxim is in conflict with another. So if maxims could be like, which are certain principles of law, if they could be in conflict with one another, then there seems to be a problem. Then there seems to be no necessity of maxims. So that's the position of maxims of law. Okay, maxims of equity, not maxims of law, sorry. Because when I say maxims of law, that includes common law as well. So here, as we study, we will be focusing essentially on maxims of equity. So there are 12 maxims, okay, which are quite often referred to. And as of now, all those rights, estate interest under equity that we'll study, have emerged from applications of one of these maxims, okay, in different ways. So let's start with two definitions of maxims. Okay, in general, maxims are nothing but short sentences, phrases. Okay, that convey something. Okay, that convey something, some moral standard, or here we will say certain equitable, standards. So let's look at some other important definition, one given by Salmond. He says that maxims are proverbs of the law. Okay, maxims are proverbs of the law and provide useful means for the expression of leading doctrines of law in a form which is brief and intelligible. So yes, okay, so there is a law, and that can be better conveyed in the form of maxims. Okay, that's what he's saying, but he's not referring to maxims of equity. He's just saying that these just convey certain doctrines of law, certain leading doctrines of law. Under what law? Could be common law, it could be other laws as well. So yes, that's essentially what maxims. Okay, I don't think definition is really the issue here. Another definition is Oxford reference. It says maxims are short, pithy statements used to denote the general principles that are supposed to run through equity. Okay, so these are nothing but certain general principles which run through equity. So they are referring specifically to equity. Then they say that although often inaccurate and subject to exceptions, okay, they are commonly used to justify particular decisions and express some basic principles that have guided the development of law. So they are accepting that they are not universal, like in the sense that they do not have universal validity, nor are they completely accurate. Okay, because there are always certain exceptions to the application of these maxims. But then what are they then? Okay, so they say that they are commonly used to justify particular decisions. So when a decision is given, the judges might say that, okay, we refer to this maxim, and then we come to this conclusion. Okay, so they basically express some basic principles, okay, that have historically, I will focus here, they don't say it, but they have historically guided the development of equity. So as of now, the maxims have little validity of the way they might have had like 200 years ago, but then they are still used to basically justify the decision which is arrived at. But you can do even without that quite often. So one of the criticisms which have been put by Snell regarding maxims is that maxims are nothing but but judges way of excusing themselves from giving concrete reasoning for why they have arrived at a particular decision. Okay, so this is just a way of saying that, okay, this is the principle of law and this is why this is the outcome, without giving you the detailed reasoning that they applied in coming to that outcome. So yes, that's the position of maxims. So yeah, it is very controversial, but nonetheless important for us to know. And then we have better understanding of other equitable, principles, or in laws of equitable principles which have been statutorily enacted. It's easier for us to understand. Like for me, since when I was doing my law, I had difficulties in understanding, for example, the different remedies which are available. So why should I have many different remedies? Why should I not have certain specific remedies? So now in the hindsight, I understand why these different remedies were available to me, okay, are available to me. So a unique history and origin of equity as a separate branch of law makes it easier for me to understand all that. So it's even though you will not be directly applying them anywhere, but even then it is important for you to understand. For example, later on when you study trust, you will see how these maxims might have played a part. So there are 12 maxims in total. Okay, what are those? I mentioned the other day. So the first one is equity will not suffer a wrong to be without remedy. So essentially it's that maxim of ubi just ibi remedium. Okay, then you have equity follows the law. It essentially there says that equity doesn't contradict the law. Equity basically follows the law. If there is law, no law, equity will not come in vacuum. So ideas like that equity follows the law by analogy, something like that. Then the third one is where there is equity, the law shall prevail. So if there is a balance of equity between A and B, If someone has, in addition to that, a right under the law, then the law shall prevail. We will discuss this in greater detail in time. And the fourth one is where the equities are equal, the first in time shall prevail. So, for example, A has a particular equitable right, B has a particular equitable right. So, in such case, the maxim says that the equity that emerged, okay, equitable right that emerged earlier, the first in time shall prevail. Okay, these are quite self-explanatory. And then fifth one is he who seeks equity must do equity. Okay, so because it was historically it has been subjective discretion of the chancellor. So when the chancellor says that I will do equity to you, it also expected that you also do equity. So these are some of the maxims. Okay. Then sixth one is he who comes into equity must come with clean hands, because it is a matter of conscience, some kind of moral parameters there. Okay, so when you seek equity, you should come with clean hands. Okay, then delay defeats equity. Okay, that's like some kind of application of, if you remember, those time bird pains. Okay, something like that is applied here as well. Okay. Then you have eighth, equality is equity. Not all kind of equality though. I'm not talking about absolute equality. Okay, the meaning of equality here varies. Although broadly we can say that equity considers some kind of equality. Now what kind of equality is that, we will discuss. Okay, it's not absolute equality. Of course, that's not what equity is talking about. And ninth one is equity looks to the intent rather than the form. Which one was concerned more about the form? It was the common law, and because of that problems arose, and that's why you have equity. So this maxim says nothing but that equity looks to intent rather than to the form. So for example, rectification of instruments, etc., might come under this. Okay, so then 10th one is equity looks on that as done which ought to be done. Okay, so it's quite moral in its in how it says. So that which ought to be done, equity considers that as done. Okay, even when it is not expressly so. Then you have 11th, equity imputes an intention to fulfill an obligation. Okay, so it is an assumption though. Okay, so when something is done, even though it is not expressly said that it is being done in fulfillment of an obligation, equity assumes or imputes the intention that there is an intention to fulfill the obligation. We'll discuss all specific examples later. And last, you guys know about this already, equity acts in personam. Now there are disagreements as we discussed in the last class. Okay, so we will discuss that again later on in this maxim. So these are the 12 different maxims that we will be dealing with. So today let's start with the first maxim. Okay, the first maxim is that equity will not suffer a wrong to be without a remedy. Okay, so as I told you, this is nothing but a broad restatement of the maxims that you have already studied, called ubi jas ibi remedium. I mean, where there is a right, there is a remedy. Okay, so this is also something which is quite often used generally, even in common law. But then it has a very important particular meaning under equity. But then, is it universal though? Is it universal though? It is not. So that's the criticism. If this maxim that I just mentioned to you is not universally applicable when it comes to equity, then why even have this maxim? Okay, so maybe I'm talking about this maxim is nothing but useless talk. That's it. So maybe we can do even without all these maxims. So that's one of the point of view which has been taken. However, what we cannot ignore is that this particular maxim, with all the exceptions, you cannot talk about maxims without exceptions, has played a role. I mean, if you were to think of this as a principle, this principle has played a good role in the development of certain equitable rights, interests, etc. So this is a principle that you guys have already studied earlier. Okay, so in that famous case of Ashby versus White, okay, where it was said that when the law clothes a man with a right, he must have means to vindicate and maintain it, and a remedy if he is injured in the exercise and enjoyment of it. And indeed, it is vain thing to imagine a right without remedy, for want of right and want of remedy are reciprocal. So in this famous case, it was already stated, okay. But then here it's a matter of common law, but the same principle also applies in case of equity, okay. Now the question is that what does this maxim really convey? Does it say that in every case where we can think of a right, there will definitely be a remedy? Is that the case? Is it, talking about this in a moral sense of the term, in the sense that even when there is no legal right, equity might even then recognize a right under certain moral principle and hence provide you remedies? Is that the case? We'll have to look into it. But for now, I can tell you that yes, that is not the case. Okay, at least in today's time, maybe earlier, but in today's time, that's definitely not the case. Okay, so not every moral right will be recognized. Now it has become specific law, so all the more the case that all these subjective moral considerations do not play any part here. So essentially what it means that each and every right, okay, if you have any right under the law, common law or statutory law, okay, so each and every right has to be enforced, okay, and if any wrong is done with respect to your right, then it has to be redressed, okay. So that's the principle that is being referred to here, okay. So Snail had said that wrongs were redressed only in those cases in which were not taken up by the common law owing to certain technical difficulties, okay. So where does that happen? So if you can think of auxiliary jurisdiction, okay, if you can think of auxiliary jurisdiction, rights are recognized, remedies are also there, but because of certain other technical difficulties, for example, no access to documents or witnesses, because of that remedy is not possible under the law, then you could approach the court of equity, and court of equity will give you remedy. So in such case, even though you didn't have a right, you have a right, you nonetheless didn't have remedy. So in such case, the court of equity played a part in giving you remedy. So one can say that auxiliary jurisdiction is the best case of application of this particular maxim. That is, equity will not suffer a wrong to be without a remedy, or vijus ibi remedium. However, the same can also be applied to other jurisdiction that we discussed. Okay, so for example, exclusive jurisdiction. Why don't we say that? Because in case of exclusive jurisdiction, it is not merely a case of remedy, but even a right is recognized. Okay, so it is. In exclusive jurisdiction, it's much more than merely this doctrine. Okay, you can apply it to a certain extent in concurrent jurisdiction, in the sense that in concurrent jurisdiction you have a right, you have remedy, but remedies are insufficient. So yes, because of that, you can seek remedy in the court of equity, and hence yes, you can relate that. But most importantly, application of this maxim is seen in case of auxiliary jurisdiction, as we had discussed. Okay, so three different cases, but most importantly in the third case, that is in the case of auxiliary jurisdiction, this particular maxim is applied. Now some of the cases, you can probably take up any example. Okay, so in this book you might see that, okay, examples which have been given. The first one is the enforcement of trust. Okay, so we have already discussed here this example. So you entrust certain property to someone, and for for the beneficial interest of someone else. So in such case, you know, because the sestri you trust, the beneficiary here, okay, his right is not recognized under the common law, but it is recognized by the court of equity. So if there is a right recognized, common law also no, equity provides you remedy. So you can say that these are the cases in which this particular maxim is applied. But more importantly, it is applicable. Yes, yes. Mm-hmm. Yes, it doesn't matter. It does not matter. But the thing is, uh, that would be the historical position. What happens as of now is that not every right will be recognized by the court of equity either. But the idea, of course, under common law, you have certain, laid down rights. Only when certain rights are not recognized under the common law, you try to find that right under the equity. So historically, there was a subjective discretion of the chancellor to either recognize or not recognize your right. But as of now, all those rights are laid down under the law of equity. So if there is a right under the law of equity, so your remedy will also be provided to you. Okay, so that's the position. Okay, so Ravi? Okay. So yes, however, this maxim, okay, has its own limitation. Okay, so there are certain other examples of auxiliary jurisdiction provided here. Go back and refer to them. It's the same thing that I have already explained. Okay, so if there are any specific remedies, for example, discovery of documents, something like that is provided. Clearly, that is the case of application of this doctrine. Okay. Anyway, so there are certain limitations. Okay, those limitations are what Snail had directed, towards this maxim as criticism. What are those? That the first one is where the right is merely moral one and is not capable of being judicially enforced. Okay, so what is this? Is exactly what I just told you. Okay, only those in those cases will you be provided remedy where the right has been recognized either under the common law or under the law of equity. Okay. If you're talking about any other moral entitlements, this principle does not apply now. So that's the first limitation. The second one is that equity does not interfere to remedy any wrong where the right and the remedy both completely belong to the domain of law. Now, this is again problematic in the sense that uh, what it is essentially saying is that if the right is under the law, okay, and remedy also purely belongs to the law, okay, and no separate remedy has been recognized under the equity, okay, then in such case you will not just go there and say that okay, I'm entitled to certain equitable remedy. But again, this is a limitation that applies now, but probably not historically. Okay, so historically the chancellor exercised much more, discretion. And thirdly, where a party has destroyed or lost or waived his right to an equitable remedy by his own act or laches. Okay, so another maxim is there. Okay, so you cannot slumber over your rights. Okay, so if and secondly, it's that okay. So for what that essentially means is that the law of limitation applies here as well. Okay, uh, so, and apart from that, if the right has been destroyed or lost, or if you have waived that right, okay, in such case, of course, it's self-explanatory that remedy will not be available. So, laches is another exception, limitation to that. Apart from this, another criticism that Snail has specifically directed against this maxim is that equity follows the law, the next maxim that we are going to study. Okay, that maxim says that equity follows the law. So, if equity were to follow the law, okay, then where is the question of equity providing you separate remedy? It just does not arise, but in practice it does. So what he is saying is that these maxims are anyway of no use as of now. That's his position. So are you guys clear till now with the first maxim? Equity that is ubi ibi remedium. Equity will not suffer a wrong or to be without remedy. Is this clear? Yes, Priscilla, tell me. The limitation. So it says that equity does not interfere to remedy any wrong where the right and remedy both completely belong to the domain of law. So what does that mean? Where both the right and remedy are adequately provided to you under the law itself. Okay. In such case, additional remedy will not be provided to you by the court of equity. Okay. Now this could have two different meanings is what I was trying to explain. What do I mean? So historically, it might have been the case that even when the remedy was provided, in fact, under the law, you see in concurrent jurisdiction, um, equity nonetheless provided you remedy because it thought that the remedy is inadequate. Okay, but what happens now? As of now, that's not the case because specific remedies are available to you under the law as well as equity. So if it is available to you, you get it. If it is not, you don't get it. So what is essentially being said here is that what is the use of this maxim? So that's it. That's the second limitation of this maxim. So was I clear, Priscilla? Okay then. If the first maxim is clear, we'll proceed to the next one. Okay, the next maxim is examples I hope are clear. Okay, essentially two examples were given. One is the trust, the other one is basically case of any auxiliary jurisdiction would come under the first maxim. If that is clear, then let's proceed to the second maxim. The second is equity follows the law. Now this is again something that we have already discussed, nothing new here. Why is that the case? So this is nothing but that question, if you remember, whether equity and common law are in conflict or are complementary. Okay, if you say that equity and common law are complementary or supplementary, then you are basically saying that this maxim is true. Okay, but if you say that equity and common law are in conflict, as Hofeld says in his entire analysis that we discussed the other day, then you are saying that this maxim is utter balderdash. Okay, this is complete nonsense. Okay, means nothing. But then in England, there is still this assumption that equity follows the law, that equity does not in every case frowns upon the law, it does not negate the law. So basically, application of section 25 of the Act of Judicature 1873 is more or less not there. It's useless, is what is said. But then, as Hofeld has already proved to us, that's not the case. Okay, equity, maybe in most of the cases it is concurrent, but if there is conflict, then equity negates the law, or at least equity emerges as the higher law. That means nothing but conflicting and coming out as superior over that of common law. So still, let's see what this maxim says. So if you have read from Snell's book, this is exactly what he says. So he starts with this quote where he says, where a rule, where a rule either of the common law or the statute law is direct and governs the case with all its circumstances, or the particular point a court of equity is as much bound by it as court of law and can as little justify a departure from it. And what is the next sentence that Snell says? Says that this is plainly false. As we have seen, equity developed rules or refused to suffer wrong. So this is the conflict with the first maxim. Okay. In some circumstances where the common law did not, which obviously had the effect of departing from the result that the relevant common law rule would have dictated. Okay, so further quotes Cardozo, okay, says that equity follows the law but not slavishly nor always. So it has been said by Snell that Instead of saying that equity follows the law, we should say that equity follows the law, but not slavishly nor always. So in many cases, I mean, in those concurrent cases, as Hopeful pointed out, okay, in those cases, equity follows the law because there is no conflict. But if there is conflict, they emerge as constitutional principles in the sense that they emerge as higher principles. So in those cases, equity prevails. So essentially, Section 25 of that Act prevails. Okay.